Hey, hello everyone. Welcome. My name is Janice, and I manage the Low Income Taxpayer Clinic here at Maryland Volunteer Lawyer Service. We are very excited today to offer a presentation which talks about the intersection between family law and taxes. It's not something that many people think about, but certainly tax impacts everything. I'm a little biased, of course, but but I think this will be a very interesting topic, and I thank you all for joining us. Just some initial slides here. If you are not already on our volunteer panel, we do encourage you to join us. It's a great way to take on some family law cases. I want to introduce everyone to our new MVLS Pro Bono portal, which is a great way to look up cases. It makes it very easy then. We also have some upcoming trainings if you'll go to our website at mvlslaw.org for information. We're going to go ahead and get started. I'm going to ask everyone that if you do have any questions to please type them into the questions box on your screen, and we will try to hold them and address them at the end of the presentation, so we don't interrupt our flow. But we have two great speakers today, so let them introduce themselves to you.
Yes.
Moges, are you there? Great.
Yes. Good afternoon, everybody. Thank you for dedicating your lunch hour to this seminar. And for those of you who have, for donating pro bono legal services to the lower income population of Maryland. Thank you, MVLS, for your service to the community and for allowing lawyers such as myself opportunities to team with you to help low-income people seek access to justice, and also for educational opportunities, both in terms of the cases themselves that are referred in seminars such as this. I've been volunteering with MVLS, taking both pro bono and judiciary cases, and that has been a benefit to my practice. Okay, so my name is Moges Abebe, and my co-presenter is Nega Teshome. I'm a sole practitioner based out of Bowie, Maryland. I handle primarily family law cases, but I am a general practitioner. I sit on the section council of the MSBA's Family and Juvenile Law section, and I'm also chief editor of that section's periodical newsletter, Maryland Family Law Advocate. Some of you may be recipients, subscribers to that. Nega is a CPA. He teaches a course on federal income tax at University of Maryland University College. He has his own CPA practice based in Falls Church, Virginia. He also has a full-time job as a supervisory auditor at the Pension Benefit Guarantee Corporation. In short, he is Superman. All right, so Nega, anything to add to that?
The only thing that I would add to that is, although I have a full-time job at the TCJA, a government agency, I'm not here advocating any government policy. So I'm here only as a tax professional from the tax perspective. And thank you. All
right, great. So my half of the presentation will be first. I will cover the change to the tax status of alimony and how that will impact divorce cases where alimony is an issue, including especially cases in which child support is also an issue. Nega will cover how the new law impacts head of household status, child tax credit, earned income tax credit, and the brand new qualified business income deduction. After Nega's portion, I'll do a brief concluding remarks, and then we'll open it up for questions. Okay.
So thank you. I just wanted to, I forgot to mention earlier that our presenters have very graciously agreed to allow the slides to be posted on our website after the presentation. So great. Thanks again.
Okay. So let's go to the first substantive slide. So the new law that we're talking about was once referred to as the Tax Cuts and Jobs Act. That's actually not its real name, but its real name is, I don't even remember what it is, but that's how we're going to refer to it. It was enacted on December 22nd, 2017, and the one of the big, huge changes that it makes is that it eliminates the alimony deduction that's been in the federal tax code since 1942. Prior to the new law, as you all probably know, alimony was deductible from the payor's income for federal tax purposes and includable in the income of the payee. The new law eliminates alimony deduction for payments under agreements entered into after December 31st, 2018, or for divorce decrees requiring payment of alimony executed after December 31st, 2018. Hopefully, you won't be among that small set of folks who, is wondering what the execution of a divorce decree exactly means. But if you are, let me know. We can discuss that. What this means is, as of the effective date, the payors of alimony cannot deduct alimony, and payees will not be federally taxed on the alimony. Now, since we're here talking about MVLS clients, your clients who will be the recipients of alimony are actually going to benefit from this because they will be receiving alimony payments free of federal tax as of the effective date. And the payors of alimony are going to get harmed by this because now they're paying all the federal income tax on the alimony that they pay. Okay, so next slide. This is the actual language from the law, 26 U.S. Code 71, and it talks about what a divorce or separation instrument is. Okay, it's what we family law practitioners are in the habit of drafting, written separation agreements, or it could be a judgment of absolute divorce, a decree of divorce. Yeah, that's pretty straightforward. So effective date is pretty straightforward as well. Divorce or separation instruments executed after December 31st, 2018. Any divorce or separation instrument executed on or before such date and modified after such date if the modification expressly provides that the amendments made by this section apply to such modification. Now, I don't see why anybody would do C2 really, but as far as, from the payor's perspective, but there it is. Next slide. I think there's a part one prior to this. No? Yeah. So as you can imagine, what this will mean in terms of alimony cases is that people who are going to be, or possibly will be, on the hook for alimony are going to be much less willing to pay it than before. As we know, family law practitioners, alimony is a hot button issue, just as child support is. And this is going to make things even more difficult because we're not going to have the tool of being able to tell our clients, hey, listen, it's not all bad because even though you're going to pay, let's say, $1,000 a month in alimony, you're not really paying $1,000 a month because you're going to be able to deduct that from your federal income tax. So it's not really $1,000, and we won't have that tool anymore once this law takes effect. This is going to mean that there are going to be more trials on alimony, contested hearings on alimony, and because of that, more MVLS clients are going to need counsel, including pro bono counsel, to try alimony cases. There's also going to be more need for expert testimony by CPAs and other tax professionals to testify on the impact of the new law. There will also be more requests for upward deviations from the guidelines in child support okay, by recipients of child support in cases where alimony is awarded. So here are some tips that I've come up with, and by the way, please feel free to share with me any creative ideas that you have on how to adapt to this new legal landscape. So if you have a case in which your client could be on the hook for alimony, or in which your client could receive alimony, there's a strong incentive to finalize a written agreement on the alimony issue in 2018. Why? Because if you have an agreement, okay, and you finalize it in 2018 for alimony, this means you can keep the alimony tax deduction, all right, into the indefinite future. So this is a big deal. We have just a little bit over 6 months, basically, to secure alimony deductibility. All right. So in cases where that's going to be beneficial, because it's going to avoid a trial for your client, or obviously if you represent the one who's going to be paying the alimony, for sure that's going to be, you know, there's an incentive to do that. So tip number 2, I apologize, it's the phone in the background. The tip number 2 is to form relationships with CPAs and tax lawyers who can consult with you on various tax issues, and those who can qualify as experts at trial, as well as collaboratively train financial neutrals. I don't know if you guys are aware of what the collaborative process is. It is an alternative dispute resolution method, which is in the Maryland law. And essentially what it means is that 2 lawyers, at a minimum, you know, each side has a lawyer, and those lawyers sign an agreement that they will only represent the client outside of court, that they won't go to court if the process breaks down, and then they work collaboratively as a team to figure out a solution that works for everybody. And one of the strengths of the collaborative process is that you can have a neutral expert retained in that process, who can then help to analyze everybody's finances and tax issues. So the collaborative process option, I think in those cases where parties are semi-cordial, is something that we need to more seriously take a look at, given the complexities that this law, new law, introduces. And I will also mention, by the way, that even though many family law practitioners don't take advantage of this, you can also hire a joint financial neutral in a contested case, okay, to analyze everybody's finances and to try to come up with some sort of a settlement. And I think that's probably, in cases where, you know, people are willing to do that, that can be really useful to both sides, rather than having a sort of a chaotic outcome that neither side really has much control over. Okay, next slide. So one of the impacts of this law is that, you know, under Maryland Code Family Law Article 12204A22, what you have is a requirement in that in calculating, in running the Maryland Child Support Guidelines worksheet, that alimony shall be considered actual income of the recipient and shall be subtracted from the income of the payor. Okay, there's no pending bill in the legislature to update 12204 to track the change in the new federal law. I'm actually on the legislative committee of the MSBA's family law section. So, and we keep track of all the pending bills, and there's nothing pending right now. So what this means is that we're going to have to calculate child support in cases where there's alimony in the way mandated by 12204. And this is going to be an interesting situation because of this lack of alignment between the federal and the state law. So if you're counsel for the recipient, you know, what this law is going to do is that it's going to actually lower the amount of child support, lower than what you want it to be, since it is, you know, if you run the guidelines with the alimony added to that of the recipient and subtracted from the payor, you get a lower child support amount. Okay. And so an argument that you'll have to think about is why there should be a deviation upwards to the guidelines recommendation with the alimony removed. All right, so you just think about arguments you can use to justify that. Of course, always remember that guidelines don't apply in above guidelines cases. Those are cases where there's a combined adjusted actual income of in excess of $15,000. Sometimes people forget about that. So remember, if you're above guidelines, you don't have this problem. If you're counsel for the payor, one of the things that you might be able to argue is that you know, the federal tax law change is not itself a basis for deviation because 12204 hasn't been amended, and furthermore, the payor is paying 100% of the federal income taxes on the alimony, and the recipient is getting that money free of federal income tax. Okay, so I'm giving you you know, thoughts for arguments on both sides, so you can mull this over. Next slide. So this is simply a hypothetical that I put together to show you know, what we're talking about in terms of if you calculate the child support in accordance with 12204 and removing the alimony from the worksheet. Couple has 2 kids, mom gets physical custody, she grosses $3K a month, dad has visitation, grosses $8K a month, mom pays $1,200 a month in work-related childcare, dad pays $200 in health insurance premiums for the kids, dad is ordered to pay mother definite alimony for 3 years at the amount of $500 a month. The difference between the 2 worksheets is not a huge amount, $155 a month. Over 3 years, it does add up a little bit. But this is just to give you an idea of what the difference might be and what you will be, some of you will be arguing. Basically running the worksheet the 12204 way and then running it without the alimony. And you may do something different too. I mean, you may do something unorthodox, like putting in the alimony, you know, just for the or just subtracting it, for example, from the payor's income, but not adding it to the, you know, to the recipients. I haven't gone through all of those, you know, possibilities and permutations, but I think the most straightforward way is to argue, okay, here's the guidelines with the alimony, here it is without. You know, you should deviate, judge, to the without alimony worksheet based on the change in the federal law, and the other side will argue against that. Next slide. Here's the code provision that relates to the departing from the child support guidelines. Remember that there's a rebuttable presumption that the amount of child support that would result from the calculation of the guidelines is the appropriate one. But you can always argue that it'll be unjust or inappropriate in a particular case. If you go further down, I have a quotation from Allred versus Allred, which says that the trial court may factor in any consideration, really, in determining whether the recommended worksheet amount is should be accepted, or the presumption that it's correct should be rebutted. Judges can take judicial notice of the change in the new federal tax law under Rule 5201. And then I have a question at the bottom here for you guys, which I don't know the answer to, but that I want you guys to think about. Can the change in the federal tax law itself, which is not particular to any case, be the sole basis for child support deviation? Okay, I think that's a question that we have to we may have to grapple with, and that, you know, particular judges and magistrates will have their opinions about. Next slide. Okay, so this is just data from the quadrennial review of child support guidelines statewide for the state of Maryland, showing, you know, how many orders followed the guidelines and how much deviation there was and some of the reasons why. I think we're going to see more deviations. That's my prediction after the law takes effect, but we're not going to have data on that until after 2022. Next slide. So one of the things that one of the ways that we can deal with this new law as far as alimony is that, if possible, we should try to transfer marital property in lieu of alimony. Why? Because marital property transfers in divorce, incident to divorce, are in the vast majority of cases tax-free. Okay, so if you are able to agree that husband will give wife, will transfer to wife, an item of property, whether that is a retirement asset, like an IRA or a 401k, or even money in a bank account that is marital property. To the extent that you can transfer marital property, do so instead of alimony. I think that it makes a lot of sense because it is avoiding this taxation of the alimony. There are some exceptions to the rule about transfers of marital property being tax-free. There are not that many of them, but transfers to a non-resident alien spouse do have tax consequences. Transfers in trust and certain stock redemptions. Okay, so if you are dealing with those situations, which are not the majority of cases, make sure to consult with a CPA or tax lawyer. Okay, so that's the big tip. Other things to note is that the mortgage interest deduction and any kinds of deductions are going to become more important in negotiations than previously. One thing to note here is that, with the mortgage interest deduction, that one of the things you can do is that the wealthier spouse, if liable on the mortgage, can pay the mortgage and claim the mortgage interest deduction, in lieu of some or all alimony. However, you have to keep in mind that if you do have such an arrangement, it will likely deprive the poorer spouse, if that poorer spouse is living in the home, from being able to claim head of household. So, as you can see, there are complexities here, and there may be unintended consequences. And what you want to do is you want to make use of experts for tax planning and for litigation. And also for, when I say tax planning, I mean trying to settle your cases or doing it within an alternative dispute forum like collaborative process. Here's a note that the new tax law does make changes to how much, that you can only deduct interest on $750,000 of qualified residence loans. The limit is $375 for a married taxpayer filing separate return. These are down from prior limits of $1 million or $500,000. Okay. And the other thing to note is the new law does suspend from 2018 to 2026 the deduction for interest paid on the combined amount of home equity loans and home equity lines of credit, unless they're used to buy, build, or substantially improve the taxpayer's main home or second home that secures the loan. I think that's going to knock out most deductions for home equity lines of credit and home equity loans. So just keep that in mind. Next slide. Okay, so I think that we're going to transition to Nega's portion of the presentation. Go ahead, Nega.
Thank you, Moges. Next slide, please. So I'll be focusing on the head of the household, how the new tax law affected the deduction that's related to this particular category. So the advantages of claiming head of the household are it helps taxpayers to get taxed at a lower tax rate. Head of the household benefits from higher standard deduction, and head of the household is also eligible for earned income tax credit. By the way, this is all of this benefits that I listed above are not new, but the value of the head of the household status actually improved due to the Tax Cut and Job Act. Next slide. So as you can see, the changes in the head of the household tax bracket compared to the current tax law compared to the prior to the new tax law, the tax rate actually reduced if you look at line by line from the first line did not change, but the second from the second downward, both the tax bracket and also the tax rate changes. Example.
Nega, I think some of our listeners are having a little bit of a hard time hearing you. Would you be able to come a little closer to the microphone?
Can you hear me better now?
Yes, thank you.
Yeah, if you look at the tax rate from 2018, the tax rates are 10%, 12%, 22%, 24%, 32%, 35%, and 37%. If you compare that to column number 3, it's a little bit higher. I think it was 10%, 15%, 25, 28, 33, and 35, and 39. So in addition to that, the tax bracket actually increased a little bit in some cases and reduced in some cases. So just compare the two, column number 2 and column number 4 to have a better idea of how much it actually changed. Next slide. The standard deduction and exemption on the federal income tax rates are in 2017. I really want you to focus on row number 3 and row number 4, basically the married filing separately and head of the household. As you can see, the value actually increased to 12,000 from 6,350 for a taxpayer filing married but filing separately, and for a head of the household, you can say the deduction actually doubled from 9,350 to 18,000. The other point that I want to point out is the personal exemption is completely removed in the new tax law. So if you have one or three dependents in your household, you no longer would be uh, getting any personal exemption. Next slide. The other benefit of the new tax law is the earned income tax credit. If you're married filing separately, you're not going to be eligible for earned income tax credit. So you have to be a head of a household, which would qualify you to claim this particular benefit. By the way, this is not new in the new tax law. It's also relevant in the old, but the changes, the value of the income tax credit change it a little bit. Next slide, please. The new child tax credit. So under the new Tax Cuts and Job Act, the following child tax credit change will take place in 2018. The child tax credit under 2018 tax form is worth up to 2,000 per qualifying child. The age cutoff remains at 17. The child must be under 17 at the end of the year for taxpayers to claim the credit. The refundable portion of the credit is limited to 1,400. This amount will be adjusted for inflation after 2018. The earned income threshold for refundable credits is lowered to 2,500. This used to be $3,000. So for someone to be able to claim child tax credit, they should have earned income of about 2,500. So the other change is the beginning credit phase out for child tax credit increased from 200,000 for someone filing single to 400,000 for someone filing joint for joint filers. The phase out applies uh, to the new family tax credit. So for someone to be able to claim child tax credit, the child must have a valid social security number to claim the refundable, non-refundable, and refundable credits. Prior to the Tax Cuts in Job Act, the taxpayer who was eligible to claim the child dependent exemption was also the one eligible to claim the child tax credit. In turn, the taxpayer and child had to meet several tests for one to be considered dependent of the other. The Tax Cut Job Act eliminates dependent exemption itself, but retains the definition of dependent to claim the child tax credit, other child or dependent related tax benefits. For the child tax credit reform purpose, this will usually mean that the child must be related to the taxpayer in one of several ways. It should be son, daughter, grandchild, etc., and must live with the taxpayer's home more than half of the year and must not provide more than half of his or her own support. Special rules apply if the parents are divorced are or legally separated. So I would advise you to speak with your lawyer with regard to if they're going to be really eligible, if you are separated or divorced. Under the previous law, strict rule of due diligence requirements apply to tax professionals who prepare returns with refundable child tax credit during the 2018 tax year. All changes to the new tax credit expires after December 31st, 2026, 25. Next slide, please. So the next few pages or few slides, I would really discuss the pass-through entities and the qualified business income, QBIs. Uh, Pass-through entities include S-corp corporations, limited liability companies, partnership of all kind, general limited, limited liability, and partnership and sole proprietorship. The profits or losses from these businesses pass through or flow through to their owner and are reported on the owner's personal tax returns. Next slide, please. So how is the qualified business income is calculated? Qualified business income is ordinary income, but does not include capital gain or losses, dividend and interest, annuity payments, foreign currency gains, reasonable compensation paid to the business owner, and guaranteed payments to a partner for services rendered. Next slide. The biggest change for pass-through entities in the Tax Cut and Job Act will be a significant deduction from QBI. QBI is short for qualified business income. The deduction can be limited in the lesser of 20% of the QBI from the taxpayer's trade or business, or the greater of 50% of the total W-2 wages of the business paid to all employees, or 25% of the W-2 wages plus 2.5% of the original acquisition cost of the business's real property. So I try to show this as an example in the next slide, how it is really calculated, and we can determine which one of which line we should be using to determine the deduction. So hypothetically, if you have three companies, and company A has a QBI of 1 million and 20%, which is 20% QBI of 200,000, and 50% wage base of 150,000, and 25% of wage basis plus 2.5 property base of 100,000. The first thing that you need to do is really calculate the 20% QBI, which is in this case 200,000. Then if you take 50% of the wage basis, it is 150,000, and the 2.5 property basis or the 25% wage basis is 100,000. So you have to compare the 50% wage basis and the 25% wage basis and take the greater of the two, and then compare that number to the 20% QBI. So, and then you have to take the lesser of the two. In this case, it is highlighted or it's bolded and the 150,000 is the amount that you should be considering to deduct from your QBI. In the second case, or in company B, you have QBI of 3 million. 20% of the QBI is 600,000. But the wage basis is 800. The 50% wage basis is 800,000, and the 25% wage basis plus 2.5 property basis is 500. Obviously, the greater of the last two rows is 800, but the QBI is the 20% QBI is 600,000. Because it is the lesser of the two numbers, we'll take the 20% QBI of $600,000 to reduce it from our QBI. In the third case, company C has a QBI of 7 million. The 20% QBI in that case is 1.4 million. and the 50% wage uh, basis is 1.2 million, and the 25% wage basis plus the 2.5% property basis is 1.3. So again, here you would take the higher of the last two rows, which is 1.3 million, and compare that to the 20% QBI, and you will take the lesser of the two, and in this case, it's 1.3 million. So it is important to note that under the Tax Cut and Job Act, this deduction for pass-through entities is temporary. It is only lasts from 2018 through 2025 tax year. While a deduction of this size is good for news for business owners, so there are some caveats. Next slide, please. So the rules, the special rules for specified service businesses, the owners of pass-through businesses in specific industries are subject to special limitation of 20% deduction in the form of a phase-out. The industries include health, law, accounting, actuarial science, performing arts, consulting, athletics, financial services, and brokerage services. Generally, for taxpayers who own these businesses, the deduction starts to phase out at incomes of 150,500 for single filers and 315,000 for joint filers. And business earning more than 207 for single filers or 415,000 for joint filers, in income will not be eligible for the deduction. I want to stress on this point. Once you start to make income of 157,500 for single filers, it is going to start to phase out, and you would completely lose the benefit once you reach an income level of 207,000 for single filers and 415,000 for joint filers. So for non-specified business that are under income threshold, the wage limitation does not apply. So if you don't own any of the industries that I mentioned in bullet point 2, you're still gonna enjoy the 20% QBI deduction. Next slide, please. So other notable issues, uh, if the taxpayer's QBI is a loss, the loss is carried over to the next year. Any deduction allowed for the next year is reduced by 20% of the 20% of the carryover uh, QBI loss. The 20% deduction doesn't apply to rental real estate, and the 20% deduction limitations are based on taxable income and not adjusted gross income. So the provisions for this section of the Tax Cut and Job Act apply to estates and trusts as well as agricultural and horticultural cooperatives. Next slide, please. So changes in the tax planning strategy. The treatment of pass-through entities is one of the many areas where the Tax Cuts and Job Act promises to fundamentally change the approach to tax planning for many business owners. Certain tax planning strategies for business that have been common for the last 30 years will be revisited and in many cases found to be counterproductive under the Tax Cut and Job Act. Example, as corporations that have historically paid bonuses to shareholders in order to withhold taxpayers to cover the corporation's profits, which flow through to the owner's individual tax returns, may want to reconsider this strategy. Taking excess salary reduces the S corporation's profit, and under the Tax Cut and Job Act, this will have the effect of reducing the value of the 20% deduction described above. To maximize that deduction, owners of some of the S corporations may want to minimize their own salaries and bonuses. However, reasonable compensation rule will still apply. Sole proprietors and owners of partnership in specified industries with income phase-out rules, particularly those with no employees, may want to consider changing their entity structure to an S corporation in order to maximize the value of the pass-through deduction. Some businesses in specified industries, especially those just over the income phase-out rules, may find it advantageous to change their strategy with regard to Section 179 and bonus depreciation in order to impact their TBI and capture the pass-through entities. So there's a lot of strategies here, and what I really want to emphasize is, if you're not sure what your tax situation is, I would really encourage you to speak to a tax professional. Next slide. S corporations that have historically paid bonuses to shareholders in order to withhold taxes to cover the S corporation's profit, which flows through to the owner individual income tax returns, may want to consider this strategy as well. Taking excess salary reduces the corporation's profit under the Tax Cut and Job Act. This will have the effect of reducing the value of the 20% deduction described above. To maximize that deduction, owners of some S corporation may want to minimize their own salaries and bonus. However, reasonable compensation rule applies. We actually went through this slide. Do you have the next slide? Yeah, so in summary, the tax cut treatment of pass-through entities is complicated, and regulations aimed at clarifying it undoubtedly will be issued by IRS. In the meantime, if you have questions about how you can prepare your business for these changes, I'm happy to take new clients and my contact is listed below. And this is all about my slide, and thank you.
Okay, thank you, Nega. Folks, please keep in mind that all of this is new, and we're all trying to figure it out as best we can until we're able to get more guidance in the form of IRS regulations, which we're waiting on, and also U.S. tax court rulings, of course. But feel free to pose any and all questions. And also, please be creative and share with us any strategies that you've thought of that we haven't hit on. What I will say is that there are two really big points that you should take away from this. Number one, to the extent that you can, settle all alimony cases in 2018. Okay, there's a lot of advantages to doing that, as we discussed before. And the other big takeaway is that you should form relationships with tax professionals, CPAs and tax lawyers, who can serve as consulting experts to help you figure out all of these complications, who can serve as joint neutral experts if you have a relatively cordial relationship between the parties, where you can take advantage of a joint neutral expert to analyze the tax repercussions of various settlement options. And then, of course, you do need to form these relationships, when you go to litigation, because you need an expert to testify on the tax ramifications of various possible rulings that the judge could make. If you're representing MVLS clients who are likely to be recipients of alimony, make sure that you have really good discovery requests, particularly for documents, requests for production of documents, so that you can actually compare the tax returns of let's say, if the spouse who may be paying alimony as a business owner, you want to look at the tax returns before and after the new law. And there's going to be, a real question about, especially if those returns are significantly different, to figure out what exactly is that person's ability to pay. When you look at that slide of Nega's on tax planning strategies, you can see that there's going to be a lot of maneuvering going on here. And one of the maneuvers that people will do, one of the advantages they're going to try to take advantage of to maximize the QBI, is to actually reduce the salary. Okay, so when that is done voluntarily for a tax benefit, okay, that's going to be very relevant on the issue of alimony, and also on the issue of actually child support as well. That these are the two big takeaways that I want you to think of. And one last thing is that in terms of one other takeaway is, make use of alternative dispute resolution strategies, including the collaborative process option, where both parties can have an advantage of employing a neutral tax professional to analyze all of the different options, to see if there is a legally sound compromise that can be reached, that will allow for a orderly dissolution of the marriage in a way that can benefit everybody. Because what's going to happen is that the judges are going to be having trouble with all of this and understanding all of these repercussions, and it's going to be expensive, to have a trial, where each side has a expert testifying. And so it makes a lot of sense to try to figure all of this stuff out in an out-of-court context. Of course, you can't do that in every case, obviously, but in the cases where you can, it makes more sense than ever to do that. So, thank you.
Great, great, thank you. For anyone who has questions, please go ahead and type them into the question box, and then we will review them. We do have a question here about tip 2 about head of household. Let's see if I can get back to that. Nope, maybe not. Let's see.
It should be on my slide.
Would it be here? So the question is that she's not understanding tip 2 about head of household. Nega, I'm sorry, is there another slide with some additional tips on it, or would this be the correct slide?
If you, the next.
This one?
Yes. Is the question about this particular slide?
I'm not sure I understand the question. It says that there's she doesn't understand tip 2 about HoH.
Okay, can you go? I just want to read tip 2. Okay, so I guess the question is benefit of higher standard deduction. If that is a question, if you can go to the next slide. Yes, this part. As you can see, being a head of the household, it will give you a higher standard deduction from $9,350 in year 2017 deduction to $18,000 of standard deduction. What it means is if your adjusted gross income is say $50,000, you can deduct up to 18,000 from that amount to get to the taxable income, as compared to only 9,350 in the prior tax rules.
Okay, great. So I think I misunderstood. It was actually in the first section. So let me see if I can get back to that. Was there was this the correct one? Tip number 2 here. I think this is for the impact of the TCJA and tips, part 3. Tip 2, in lieu of some or all alimony, parties can agree in writing that the wealthier spouse, if liable on the mortgage, will pay the mortgage and claim the mortgage interest deduction. However, such an arrangement will likely deprive the poorer spouse, if she or he is living in the home, from being able to claim HoH, or head of household.
Yeah, so what I was referring to there is, number one, one of the options, and this is nothing new. The mortgage interest deduction, is not fundamentally changed except for those limits on how much of a qualified residence loan you can deduct interest on. But essentially, if there is a benefit to a mortgage interest deduction, and that can be quantified, and if you have an arrangement where the wealthier spouse is liable on the mortgage, and that person can pay the mortgage instead, okay, and thereby get some of that, have that interest, the interest at least, deducted, then it makes sense in terms of negotiations with the other spouse to take that into consideration, and perhaps have equal benefit to the recipient, but without the tax, as much of a tax burden on the payor. Now, the trick about that is that the eligibility to file as head of household, okay, if you look at the eligibility factors, one of them is that you pay. I believe it's that you have to pay for household expenses, for the majority of household expenses, or something to that effect. Did I get that right, Nega?
Yes, you have to cover the expenses for more than 6 months
Of the household.
The household of that particular
right.
household.
So what I'm saying is you have to be careful in reaching an agreement like this, because if the fact of the wealthier spouse paying the entire mortgage for the entire year, for example, could make the poorer spouse not eligible to file as head of household, and thereby lose all of the benefits that Nega went through associated with that tax filing status.
Great, thank you. We have another question here. Can the parties assign the ability to claim the child tax credit to the non-custodial parent?
Nega, do you know the answer to that?
That is, I'll go back to the previous rule. To be able to claim a child and get the benefit of the child tax credit, in the prior rule, you have to be able to provide support to that child for more than 6 months. That is what what the rule says. But if the court decided, or if there are any legal issues that would transfer the custodial ability of the party, I'm not sure about, and you probably need to speak to your legal professional to
So what I will say is that remember, that the eligibility for this federal child tax credit, the factors are set by the federal government, and you can't claim the child tax credit unless you're eligible for it. Okay, so you can't assign the credit to a party that isn't eligible for it under the federal rules.
Okay, great. Thank you. Thank you. Again, if anyone has any questions, please go ahead and type them into the question box, and we'll be happy to review them. I think this has been very interesting. There's a lot of shifting going on still, I think, and so I think it's still somewhat unclear as to how it's all going to settle out. So, so I want to thank our two speakers for this great introduction to this. I think it certainly has an impact on how you're going to practice in the next 6 months. It sounds like it's going to get quite busy with all of this. And then also, oh wait, actually, there's a point about IRS form 8332 controls, not the divorce agreement. So there are specific circumstances for gaining. I think this is regarding the tax credit that you were just talking about. So so that the divorce agreement does not allow you to decide who can claim the child tax credit, but it really, just like you said, it's dependent on who actually is eligible for that credit then. So, but anyways, yes. So thank you. So wonderful. Well, thank you all for joining us today, and thank you to our wonderful speakers for enlightening us about this very confusing Tax Cuts and Job Act. And once again, it's helpful to see. Oh, wait, here's one more question. Under the federal rules, are individuals filing separately disallowed from claiming EIC?
That's correct.
Okay, so they are disallowed.
They are not able to claim earned income credits. That's correct.
If you're married filing separately.
That's correct. That's why the
Okay.
head of the household is really essential for them to be able to claim the benefit.
The benefit of that. Okay. All right. Very good. Okay. Well, thank you. Oh, one more. Are you aware of any temporary IRS regulations or rules or forms on the pass-through calculations, and how will they be done?
Basically, I provided the current rule, but I'm not really aware of any specific other calculations that are out there.
Okay. And I think you were saying that we are also waiting to hear more from the IRS regarding this.
They probably would come up with more guidance, but I don't think the rule itself would change. They would be much more examples, more clarities on this, I expect.
On this, okay, okay. Is there sort of an expected time frame, do you know, of when more clarity would be available?
Well, I hope that it would come out before December 31st, 2018 for it to be applicable in 2018 tax returns.
Okay. Okay. Very good. Then.
Yeah, I can't. Nobody can really say what they have on their calendars.
Right. Right. Well, I think everyone's working very hard to try to get some clarification and to provide clarification, because I think there's a lot of questions and a lot of murkiness right now. Okay. So definitely. So, well, thank you both for sharing this information with us and touching upon the impacts. It really forces us all to think about things a little bit differently now, which in the way to best improve the circumstances for our clients going forward. It's a little bit tricky. Like you said, it would be nice to have some more clarification, but certainly as we go forward, hopefully we'll all learn a little bit more and all be able to apply this correctly to our clients going forward. So thank you, listeners, for joining us. As I said, we will be able to post these slides so for reference, and thank you again. Take care, everyone. Bye-bye.
Thank you.